Start over. Start. Good evening, everyone. We'll start with our discussion about social justice paper of this year. There are 5 questions essentially of social justice. Even though the differentiation between social justice and governance becomes difficult, we have pointed out 5 essential questions on social justice. Mostly it relates to social justice, even though there are parts of governance, polity inside it. But first, we'll be starting with social justice discussion. First, question number 6 that was in the paper, GS2. It says women's social capital complements in advancing empowerment and gender equity. Explain. So, question is asking how is women's social capital is advancing their empowerment and gender equity. Now, empowerment can be women specific and society at large. So let's delve into it. In terms of introduction, we'll first define what social capital is. In the context of women in this case. Example, social capital refers to networks, trust, and cooperation that women build through collectives which act as catalyst for empowerment and gender equity. So what are these networks, trust, which act as catalyst? These are we usually know as self-help groups in rural areas. So individuals, women act as self-help groups. These self-help groups eventually promote women empowerment. They create a society around the women in which women use it to forward certain economic and political agendas. Now, moving into the question, role of women social capital in empowerment. So, how does social capital play a role in empowerment? We understood what social capital is. Now, how it is causing empowerment. See, SHGs, self-help groups, as we discussed. First, how economic empowerment is happening. This is the first point. How economic empowerment is happening through self-help groups, cooperators, microfinance institutions. So these self-help groups act as microfinance institutions in which women can borrow from their peers in SHGs and use it to start some business or fund some education, and then they pay it back eventually. These microfinance institutions act as very powerful tools of women empowerment and rural development at the same time. This increases their access to credit and livelihood diversification. Using this, they start very rudimentary factories such as making pickles, making papad, making agarbattis, things like that. So it gives livelihood opportunity to women. Now, how it causes social empowerment. So economic empowerment also transforms into social empowerment. How does that happen? It breaks the isolation of women from just being limited inside the houses to going outside and earning bread. It creates mutual support group for women. Any kind of domestic problems they are facing, the women outside act as a support group. Solidarity against discrimination, violence, any kind of gender violence that is happening at home, women can always seek support of the women outside. Similarly, then third point being political. How political empowerment is happening. There is grassroots leadership through these SHGs. So there is a women group and there is a leader of those women group. Then there is Panchayati Raj participation now of these women group transforming into a political group altogether. And policy advocacy. They once the group is formed, they go ahead and advocate certain policies or demand certain things from the Gram Panchayat, or even show their non-compliance or show their mistrust into certain policies or into certain leaders. So they act as a pressure group also. They also act as a pressure group. Digital and educational. How this empowerment is happening. This is number 4. Digital and educational empowerment. Online women networks are connected. So these SHGs all have those WhatsApp groups or Telegram groups. Similarly, peer learning and mentorship. If somebody has started a business, they mentor their peer into helping them into the business, use their experiences. So this acts as a learning organization, as a learning network. How it complements gender equity. So we have understood how it creates empowerment. Social capital creates empowerment. Now we'll see how it complements gender equity. It strengthens formal rights like reservation and women entitlements. So gender equity, such as we know certain problems such as panchayat pati traditions. If there are strong women group, they'll oppose this. That even though women is elected, she is not being able to go across and govern. Then a male member is governing in her name. When there is a strong women advocacy group, they'll replace this tradition. They'll act against this tradition. It promotes inclusivity in decision making. So larger women groups, such as business groups, social groups, they act as an economic vehicle for change, such as the Kudumbasri model. This is a cooperative society in Kerala. Similarly, Seva. These are networks of women or cooperatives that act as economic and social vehicles for change. It reduces gender gaps like health, education, and income. So, how equity is achieved? It creates a space where women healthcare is prioritized, women education is prioritized, and they are getting economic empowerment through income, extra income. Helps shift social norms towards equality. So once this social group is determining what kind of work needs to be done in a rural setting, they are determining what decisions are being made at the grassroots levels. So as an example, Kudumbashree model is there, Seva is there, and a global example would be Grameen Bank model or women group in Bangladesh. This is an idea that that is also adopted in India as SHGs or microfinance institutions. So this is a global best practice. What are the challenges and limitations regarding this? Even though this is not asked, the question exactly asks us, explain. So limitations are basically, while writing a line of limitation above conclusion, we'll write that there is existing patriarchy, there is low literacy among women, there is a digital divide and lack of institutional support. So digital divide is there, lack of mobile phones with women. So initial support that they need is not coming from anywhere. Conclusion, women's social capital is a powerful complement to laws and policy and transforming empowerment into collective strength and ensuring gender equity. So essentially, women's social capital transforms governance to a more equitable levels. It makes governance rooted. Now, moving on to the next question. Civil society organizations are often perceived as being anti-state actors than non-state actors. Do you agree? Justify. It's a 150 words question. It's a very short answer we'll have to give to this. First, we'll define what civil society organization is. It's a voluntary non-profit and non-state entities like NGOs, self-help groups, advocacy groups, grassroots movements. So we saw this as something called the Seva in the last answer. Then what role do they play? They support governance and also act as watchdogs of certain policies. They help in implementation of certain things, for example, the self-help group movement, and they also act as watchdogs. So any kind of governance or any kind of implementation problems that is being faced, they act as watchdogs to it. Hence, this acting of watchdog creates an anti-state perception. Okay. Why CSOs are perceived as anti-state? Two facets to it. One, some NGOs do act against the government and according to foreign funds. So recently, protests against the Kudankulam nuclear power plant. So an NGO having a lot of foreign funding was trying to stop this nuclear power plant to come to fruition. Why? Because the funders of this NGO did not want Russia to make a power plant there in Tamil Nadu. So this creates a perception they are acting anti-state. There are some NGOs also who are very much doing forceful conversions in a few pockets in India. This has become very rare with government interventions and stricter laws, but these things also exist. However, overall, normally these civil society organizations are considered anti-state because of these reasons. Accountability role. They criticize the government policy, expose corruption and human rights violation. So there are certain human rights violations that take place wherever AFSPA is implemented. And some civil society organizations come up with reports that showcase how human rights violation are happening, and then they're perceived as anti-state or against the government. There are advocacy movements like Narmada Bachao Andolan, RTI movement, anti-mining protest. So RTI movement, Narmada Bachao Andolan were all seen as anti-state movement because they were trying to stop large-scale governmental projects in forest lands. Similarly, they keep a check on power, or on arbitrariness of exercising power. They mobilize citizens. They challenge the state monopoly in welfare delivery. So any kind of so these are the organizations that ensure uh, environmental impact assessment or social impact assessments are done. For example, EIA or SIA has been done. These organizations ensure these things happen. And there are global linkages, sometimes funded externally, seen as influencing sovereignty of India. So these are the reasons. Even though some organizations are actually working against the state or against development, but most organizations or most CSOs, maximum amount of them are for these three reasons, or the first three reasons, because they speak against the government or against what all state policies or what all problems are there in the state policy. Why CSOs are not anti-state but complementary? They are complementary because they ensure service delivery is good. In education sector, there is Pratham, which ensures or brings out a report every year, the state of education in India in terms of what are the learning outcomes that are there. Similarly, in healthcare, there is CRY, uh, Child Rights and Youth, so children healthcare. Similarly, SEVA is there. In livelihood, there is Pradhan. There is also another called the Akshay Patra Foundation. They work in delivering midday meals, ensuring food security is there. Then there are similarly other organizations that ensure grassroots delivery of services. They bridge the gap between uh, the most vulnerable citizens and states and the government service delivery. Reach vulnerable communities where state capacity is weak. So wherever there are vulnerable communities, they send medicines there, they send basic food material there. So they bridge the gap, they democratize, they encourage participation, grassroots leadership, and policy feedback. Similarly, they act as disaster relief and social work. During COVID-19 or floods, these civil society organizations do a large scale charity work. You must have seen a certain food center, certain clothes distribution center ran by these NGOs and civil society organizations. So perception of anti-view arises when CSO questions government actions. In reality, there are non-state actors aiming to deepen democracy, social justice, and inclusivity. But there are some actors, of course, who act against the development of this country. Some actors who are whose motive is to stall certain projects, certain developmental projects. They so in the date of maximum governance, these non-state actors are extremely important to act as constructive partners and watchdogs, and they complement governance at the grassroots levels. Why are environmental pressure groups? What are environmental pressure groups? Discuss their role in raising awareness, influencing policies, and advocating for environment protection in India. It's a 15-mark question. So we'll introduce with the definition what these pressure groups are. So they are non-state actors, voluntary, issue-based approach organization. They mobilize public opinion and influence government and corporate actions for environmental protection. As I discussed before, they ensure environmental impact assessment is being done for every project. They act as watchdogs. Now, example are Chipko movement, Greenpeace India, Center for Science and Environment, CSE. What is the role in raising awareness? Discuss their role in raising awareness, influencing policies, and advocating for environmental protection. So we'll break down this question according to whatever the words that are being asked. Role in raising awareness, grassroots campaigns such as Chipko movement, Apiko movement, spreading environmental consciousness among rural communities. Similarly, mass media and social media campaigns. They create awareness on pollution, climate change, biodiversity, and mobilize youth and students and civil society around sustainability issues. Similarly, what is the role in influencing policies? Advocacy led to right to information on environment, environmental impact assessment norms we have discussed, and judicial activism. So any kind of problematic laws that are brought against the environment, they use law as a tool to get to deliver developmental goals or certain environmental protection goals. So exactly, environmental pressure groups. So a lot of so a recent there are a lot of judgments when it comes to definition of forest in India that that protects the environment or increases the jurisdiction of what exactly forest is and limits the role of the government in destroying those areas. So recently you must have heard M.K. Ranjit Singh versus Union of India. This is a judgment of last year where the government went ahead, or the Supreme Court gave a judgment of protecting or creating right to environment as an important, as a fundamental right under Article 21, and it also was protective of the wildlife of great Indian bustards in Rajasthan and Gujarat. So groups like these are the reason there are certain uh, fundamental rights that extend to citizens, and these are environmental rights eventually. So right to a clean environment became a fundamental right because of these groups. Similarly, we see Silent Valley movement. They halted the hydroelectric project because it was going to submerge a very important biodiversity hotspot in Kerala. CSE reports influenced policy on air pollution, waste management, and sustainable energy. So, Center for Science and Environment, their reports have a huge influence. Lobbying in climate change negotiation, such as India's nationally determined contributions, the COP participation. So, these groups act as pressure groups, as lobbying groups of getting more environmental or greener concession from the government. Role in advocacy for environmental protection. So, a lot of public interest litigation cases by MC Mehta shaped the environmental jurisprudence in India. So, campaigns against deforestation, industrial pollution, uh, urban air quality issues. So, these were the things. Partner with government in implementing Swachh Bharat Abhiyan, renewable energy promotion, wildlife conservation. So, we now saw how wildlife conservation happened with that judgment, MK Ranjit Singh versus Union of India. Moving on, what are the challenges and criticisms of this? They are sometimes accused of being very anti-development in nature. Funding and foreign influence controversies are also there, that foreign money is influencing Indian policies. And this is a very problematic thing. Similarly, there is limited outreach in rural and marginalized regions. So what is happening is these groups are very much limited in urban pockets or very elite pockets. Conclusion would be they act as conscience keeper of society, balancing development with sustainability and ensuring India's environmental democracy. So these are keywords. So by these three, we have answered what all the demand of the question were. So moving on to the next one. Inequality in the ownership pattern of resources is one of the most major causes of poverty. Discuss in the context of paradox of poverty. So what is this poverty paradox that we have? India has abundant natural and human resources, yet poverty persists due to unequal distribution of ownership. Rich mineral states like Jharkhand and Orissa face high poverty levels, as we know a term called Dutch disease. That areas with very high mineral resources end up being very poor because they are over dependent on those resources and do not focus on human development. This is the paradox, that having abundant human and natural resources, still the country is poor. Now, inequality in the ownership of resources and how it results in poverty. One, there is land ownership concentration. 10% households own 50% of the land, and landless farmers remain poor. So eventually, with time, the average area under an individual is growing less and less. So landless poor, and even though people with land, their land is getting smaller and smaller. Similarly, the same as with capital ownership. So industries, financial assets are concentrated into very few hands, very few elites in a very few cities. They control these things. Then comes natural resources. minerals, forests, often controlled by elites or corporations, displacing tribals and marginal groups. So the protest against POSCO in Orissa is an example. Similarly, urban poverty is also there, or urban property, I beg your pardon. That means real estate speculation widens urban and rural poor divide. So, urban poor lives mostly in a very small pocket of land, and that is where slums grow, while the rich live in very spacious livings. So, inequality in ownership of resources is the first point. Second, paradox of poverty in India, what it constitutes. Resource rich regions are poverty hotspot, the Dutch disease that we know of. Second, hunger amid surplus food. Despite record food production, malnutrition persists due to poor access and affordability, and also a lot of hidden hunger exists. Hidden hunger. That means what? There is a lack of micronutrients that is required to individuals that poor cannot access because of high prices. Energy paradox. Coal-rich states face uh, energy poverty in rural households. So, lot of power cuts are there in states like Chhattisgarh, Jharkhand, Orissa. Power cuts, even though there is abundant coal resources in those regions. Similarly, employment paradox. Skilled, educated youth, they remain unemployed while industries face labor shortage. That means there is a significant lack of skilling. So industries are facing labor shortages, skilled labor, while a lot of educated youth do not have jobs. So this is a huge paradox that is there. Then, what are broader implementation challenges? Inequality breeds social exclusion, unrest, and migration. It worsens caste, tribe, class marginalization and prevents equitable growth, perpetuating intergenerational poverty. So these are so caste is being transformed into class. Now, what is the way forward? What are the corrective measures that one has to take? One, effective land reforms and land pooling measures so that land pooling so that fragmentation of land holding is solved. Fragmentation of land pooling is solved. Then inclusive resource governance, especially for forest and tribal dwellers. So correct implementation of forest right acts and PESA, wealth redistribution via progressive taxation and social safety nets. More ideas such as uh, skill development and financial inclusion. More ideas such as universal basic income can be explored. Similarly, more and more skilling programs, of course, Pradhan Mantri Kaushal Vikas Yojana. The paradox of poverty reflects not scarcity but skewed ownership. There is no scarcity. The ownership is not correct. Bridging inequality in resources is essential for inclusive and sustainable development. So, for inclusive development to happen, for uh, that is where redistribution of resources is very much important. Inclusivity, and also there has to be governance should be focused on more inclusive governance. Now, moving on to the last question. National Commission of Protection of Child Rights has to address the challenges faced by children in digital era. Examine the existing policies and suggest measures the Commission can initiate to tackle the issue. So, what is the significance of digital era and how digital devices are affecting children's lives? Online education, online games, uh, entertainment and socialization, social media, and what are the concerns right now? So, there is address the challenges faced by has to address challenges faced by children in the digital era. What are the challenges? So, what are the challenges? Challenges are online abuse, uh, lack of digital hygiene. So there is a lack of digital hygiene. Then there is cyberbullying. Social media is causing addiction to people. Similarly, exposed to harmful content and data privacy threats. A lot of what do you call deep fakes are being also created. Deep fakes is an issue. Data privacy data is being used to bully people. Similarly, harmful contents such as child pornography, child pornography is also there. The state NCPCR's role as a statutory body under the Commission for uh, Protection of Child Rights Act, their role is to protect children in their every facet of life. They have to protect them in school, they have to protect them at their homes physically, and third, they have to protect them in a digital space. So, what is their role? They have to introduce digital hygiene. Certain games, certain social media has to have certain time limit or parental control over them. So that parental control needs to be introduced. Parental control needs to be introduced. So challenges of children in digital era we have explained: online exploitation, child pornography, cyberbullying, addiction and mental health, gaming and social media addiction affecting learning and health. So presently, the Online Gaming Regulation Act passed just last week at 2025. It does not provide how minors are to how time minors spend in playing these games, online games, can be regulated and should be under parental supervision. These things are missing. So this is a challenge. Gaming and social media addiction affecting learning and health. There are a lot of suicides because of lack of games. Games such as the Blue Whale Challenge or something. Misinformation and radicalization, exposure to fake news, hate speech. So, hate speech, there is religious radicalization of youth also. Radicalization in pockets such as Manipur, Kashmir. Children are being exposed to content that is extremely gory and harmful in nature. Data privacy concern. Children's data are vulnerable to misuse by platforms. So even advertising platforms also use children data to sell certain products and influence those young minds. There is digital divide, unequal access to safe and constructive digital learning. So there is a lack of digital hygiene overall among the population. What is the existing policy and framework? One, there is the IT Act. It addresses what all cyber crimes exist against minors. There is the POXO Act, protect children against sexual exploitation online. Third, there is a national cybersecurity policy. They have certain safety guidelines regarding children with regards to how social media intermediaries social media intermediaries need to have need to ensure that child is of a certain age to use those social media websites. There is Juvenile Justice Act. They safeguard children's right in digital context. And then there is a draft data protection bill, specific focus on child data protection. So any of the data that the usage generates of a child, it has to be kept different from how adults are. In the sense, if you send them to marketers, it will be used to manipulate child's behavior. So, and in addition to this, the IT Amendment Act, or the Digital Data Protection Bill, Digital Data Protection. This Digital Data Protection Bill had certain parental control over child's behavior, online, on social media platforms, on these gaming platforms. And of course, there are NCPCR guidelines in preventing child abuse in a digital environment. So, what measures can they initiate? They can, one, strengthen the policy, recommend amendments to IT Act and for stricter monitoring, and they can also recommend certain amendments to the newly passed Online Gaming Regulation Act to introduce whatever gaming or esports, as they say it, esports children are playing, it does not lead to excessive addiction, and parental control is there over the amount of time and places where people use these devices. Similarly, there has to be digital literacy programs, nationwide awareness drives for students, teachers, and parents. Then there has to be child-friendly ecosystem, collaborative with edtech platforms for safe learning spaces. These safe learning spaces should not have any external advertisement for something. Similarly, there is monitoring and reporting. They create child helplines and AI-enabled grievance redressal for online abuse. So online abuse, children especially fear and do not report it to parents or other authorities in the fear of getting exposed or uh, getting a backlash in terms of social backlash from friends or from uh, parents. So there has to be child helplines that secure their privacy also. Collaboration, civil society. There needs to be mental health support. So telemanas, and inclusive access and promotion of digital hygiene in schools. It has to be taught in schools. The last part, conclusion. We have identified the risk and what we can do. So what we'll write is certain way forward in terms of conclusion, that adopting certain best practices like Australia bringing out a law that certain uh, age group, below a certain age group, people cannot get into social media or cannot play certain amount of games. Similarly, China has a rule where gaming time is limited because it impacts any kind of psychological or intellectual activity of students. So, China and Australia's example can be given. So, these were the questions on social justice and how we have discussed how we will deal with each and every part of it to break those questions down. So, thank you for watching. ठीक है
शुरू किया जाए. Hello everyone, good afternoon. Today is the time for analysis of UPSC CSC paper, and today I'll discuss GS paper 2. And here you see that GS paper 2 consists polity, governance, IR and social justice. So this is Dr. Vijendra Jha, and here we will discuss about GS paper 2. And as I told you already that GS paper 2 consists four theme. One is polity, polity. Second is governance. Third is IR, and fourth is social justice. Now, if you look at the pattern of question this year, it is not different from the last year or few previous years. Now, if you look at the numbers are allocated to the polity, basically 110 marks are allocated for polity, and for governance it is a 60 marks, right? For IR it is 50 marks, and for social justice it is 30 marks. So total, if you look at total marks, right, that is 250 allocated to each GS paper. And in GS paper 2, if you look at polity question, that is 110 marks has been allocated to polity, 60 marks have been allocated to governance, 50 marks allocated to IR, and 30 marks allocated to social justice. Now, if you ask questions, the level of questions from the last few years, if we compare, now this year question was comparatively, you can say that hard. Students, called me that, sir, question was a bit hard, but it was good. It was done. So you have already done. And now look at what was the question and what would be the appropriate answer for each question. Now let me go to the next slide. And here, if you look at the question, first question, discuss corrupt practices. Discuss corrupt practices for the purpose of the Representation of People Act 1951. This is the first part of this question. Second part, analyze whether the increase in the assets of the legislators and or their associates disproportionate to their non-sources of income would constitute undue influence and consequently corrupt practices. So now if you see there are two parts, you have to focus equally to each part, and you have to write in 150 words. It means 75 words for this and the 75 words for this, right? So you have limited word, you have limited time. Now let me talk about the discuss practices for the purpose of Representation of People Act 1951. Now you all know that in introduction you need to introduce theme, right? You need to introduce theme. And what is the theme? That is RPA Act 1951. So you just write 2 line or 3 line about RPA Act. So RPA Act 1951 regulates election, and it's regulate and monitor the corrupt practices. And if someone found in such practices, their membership from the legislature shall be terminated, right? So that is the basically introduction. Now if you come to the body, now you define corrupt practices, or you say that corrupt practices according to RPA Act 1951. So after two or 3 line introduction of RPA Act 1951, now you talk about corrupt practices under RPA Act 1951. Now what is the corrupt practices? For example, corrupt practices are, for example, giving bribery, then using religious sentiment, Then also, distribution of money or other means to influence voters, right? Then, you know doing extra expenditure. So if you know that there is expenditure is limited, so extra expenditure on campaigning campaigning then also, not letting the election commission about your expenditure, then using, caste, religion, right, and other communal communal things for your for electoral campaigning, right? These are the corrupt practices under RPA Act 1951, and these all are prohibited, right? Now this is the first part. Now come to the second part. Analyze whether the increase in the assets of the legislator and or their associates disproportionate to their income source would constitute undue influence and consequence of corrupt practices. Now here you have to explain that increase in the wealth of legislator really constitute the corrupt practices. Now you have to write about according to some report. For example, Association of Democratic Reform, Association of Democratic Reform, ADR, right? That legislator letters wealth are increasing, right? Increasing after each elections, after each election, right? So this is for, you can give example of, that how many parliamentarian was crorepati in the parliament in the 17th parliament, or how many MPs are crorepati in the 18th parliament. Then you need to write about the corrupt practices, right? Now it is, generally seen that MLA and MPs wealth are increasing year by year, and it is not technically come under the corrupt practices under RPA Act 1951. So it is not a corrupt practices under 1951, RPA Act 1951. However, right, it is definitely a undue influence, and undue or due influence. It is a due influence, right? Here you can give a PUCL versus Union of India judgment, Supreme Court in PUCL versus Union of India judgment, right? That the election commission should direct every candidate to file an affidavit and declare their assets, right? Then liabilities, then education, and also criminal records, right? So this judgment helps in preventing, you know, the influencing the outcome, economic outcome, by by the virtue of being member of the parliament or the state legislature, right? Then you can give the Supreme Court verdict related to related to the corrupt practices in election. For example, right, Supreme Court has said that religion has become a monster. It is unstoppable in electoral practices in India, right? And the state must, curb on it. And if you look at the way forward, what should be the way forward? Right. Now, the way forward should be the electoral reform. Electoral reform. Right. And then you can come to the conclusion. Right. One can write conclusion before way forward. One can write conclusion after the way forward. This is a pattern of writing. You can choose your own pattern. There is no definite pattern, right? That you can write. Now, let me move to the second question. Now, comment on the need of administrative tribunals as compared to the court system. Assess the impact of the recent tribunal reforms through rationalization of tribunals made in 2021. Now, again, the word is limited. Now, there are two parts of this question. One is comment on need of administrative tribunal. So first, you should go for introduction, right? And you should introduce what is administrative tribunal. Administrative tribunal is basically a quasi-judicial body which adjudicate administrative, financial, tax related, environment related, matter. And you can give the constitutional provision. So first, introduction about administrative tribunal. Administrative tribunal. That administrative tribunal is an alternative or justice system. It is a quasi-judicial body, right, that adjudicate on several matters like administrative matters, environmental matters, tax-related matters, and so on, so on. Now, one can write constitutional provision. Constitutional provisions, right? If you look at the 42nd CAA of 1976, right, that added administrative tribunal in the constitution. Constitution, right? So there are Article 123A and 123B. Yeah. Now, if you look at, no, not 123, it is, so you can write article, right? It is, right? So about the constitutional provision, and then you should write the need for it. What is need for administrative tribunal? Administrative tribunal. Now, first is, if you look at, it is cost effective and efficient. Cost effective and efficient right? Administrative tribunals are cost effective and very efficient to dispose the matter, whether it is related to environment or related to tax related or related to administration. Now, second, if you look at, right, a specialized agency. Administrative tribunal is a specialized agency. If you look at in administrative tribunal, there are a specialized member, right? So, for example, in environmental, your green tribunal, there is a people expert on environment, along with the judicial expert, and they deliver a very just order. So this is a specialized agency. Third, if you look at that effective administrative tribunals is very effective, right? And it has given several judgment now. So that is a need for administrative tribunal. Now look at compared with the court. Compared with the court. So comparison with court. Right. So just you need to make a table better, right? Administrative tribunal, administrative tribunal, and then court system, right? Now first difference is it is quasi judicial body. It is a judicial body, right? Second, it is flexible, it is rigid. It is flexible, it is rigid. Rigid, right? Third, if you look at third differences, right? It is more broader, more broader, right? For example, green tribunal, right? So there is a specialist along with judicial expert, judicial expert. Now if you look at it is very much narrow because it is actually very much legal one. It is narrow in representation, in right representation, right? They consist legal experts. They consist legal expert, right? So that is basically we can compare between administrative tribunal and the court system. Now look at the another part of this book. Assess the impact of the recent tribunal reform through rationalization of tribunal made in 2021. Now if you look at government passed Tribunal Act 2021, government passed Tribunal Reform Act 2021, and this act rationalized the tribunal system in India. Act rationalized tribunal system in India. Right? Now, what is that rationalization? Basically, it merged several tribunals Now, The court can look into the judgment given by the tribunal. In this way, if you look at, you know, there's a rationalization of tribunal in India. Now you can conclude it, right? So this way you can write answer 150 words, very less word that you have to write. Now let me move to the next question. Here, compare and contrast the president's power to pardon in India and the USA. So introduction, you must write what is pardoning power, right? What is pardoning power? Pardoning power implies giving relief to the person, right? Either convicted or accused, because if you look at here, preemptive pardon is used in USA. So you write about what is pardoning power, and then you write constitutional provisions in India and US, right? Now, if you look at constitutional provision of India and US, Article 61, provides pardoning power to the Indian president. Indian president. Now, here, if you look at Section 2 provides pardoning power to the US president. Power to the US president. First, if you look at, right, so both president can pardon. Now, second, if you look at, the Indian president has more pardoning power than the US president, because if you look at the US president, Indian president, they can pardon in case of a state law, the violation of a state law, in case of death, in case of other, for example, reprieve, respite, remission, right? So these are the 5 pardoning power Indian president has. But if you look at the American president, they can pardon, but only in violation or for the violation of the federal law. They cannot pardon for the state law or the state court where it is called Supreme Court. Supreme Court has given the death sentence. So Indian president has relatively more pardoning power, or more pardoning power. For instance, pardon, commutation, respite, reprieve, remission, and reprieve. Now, if you look at American president, they have pardoning power related to pardon, but only for the violation of the federal law. Then also remissions, right? So they have limited power. American president, US president has no such extensive pardoning power, right? He cannot or she cannot pardon for violating the violating the state's law, but Indian president can. President can. Now this way you can, see some similarity and the differences, similarity and differences between the Indian president and American president. Now there is a second part of question, right? Are there any limit to the both the countries, right? Again, if you look at three question, 50 words for the first part of question, 50 words for the second question, and 50 words for the third question. So look at any limit. Yes, in India it is a limit, right? Right, limitation of pardoning power to the Indian president. Now they have, or he or she has to abide by the aid and advice given by the Council of Ministers. Abide by the aid and advice given by the Council of Ministers headed by the PM, right? Now it is subject to judicial review. It is subject to judicial review according to 𝐻𝐿 judgment. Judgment. Now look at limitations of the pardoning power of the US president. US president. Right. Now Indian president can pardon also for the violating of state law. The American president cannot. Indian president can pardon for violation of state's law, but the US president cannot. Right? This is actually a limitation to the US president. Now in US it is not subject to judicial review, right? In the US, the pardoning power of the US president is not subject to judicial review. Power of the president is not subject to judicial review. So we have done limitations. Now we have also limitations for writing, word. Now look at the third. What are preemptive pardon? Preemptive pardon, that's a preemptive that president. This is not available in India. It is only available to the US president. Now if you look at the US president, Biden has actually used preemptive pardon to save few portions of his own government, right? And his also some relatives. He had given preemptive pardon so that the next president cannot, punish them, right? So you should write what is preemptive pardon. Preemptive pardon. Preemptive pardon, right? So basically, preemptive pardon implies pardoning in advance, right? In the sense that someone may someone may be convicted in future, right? Now it is available to Indian president, US president. It is available to the US president. The US President Biden has used it, right? Biden, right, has used it in January 2025 to protect his relatives and members of his own government. Right? Now, right conclusion. Right? That pardoning power is an important judicial power of the executive that is used in India and in the US. So that is the third, right? Now let me move to the next question. And here you see, discuss the nature of Jammu and Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act 1929. So here, and then again the second part of the question, briefly describe the power and functions of the Assembly of the Union Territory of Jammu and Kashmir. Again, it has two parts. You have to devote 75 words for this, and you have to devote 75 words for this. Now discuss the nature of Jammu and Kashmir Assembly after the Jammu and so first you give introduction about the Jammu and Kashmir Reorganization Act 2019. So first write Jammu and Kashmir Reorganization Act 2019 changed the status of Jammu and Kashmir. It abolished Jammu and Kashmir as a state and provided two UTs, right? Namely, Jammu and Kashmir and Ladakh, right? Now, you need to talk about the nature of assembly, nature of J&K assembly. Now, you need to write the constitutional provision. Now, J&K assembly right, is governed by Article 239A, right? 239A, and it can make law. It can make law on all subjects except police and law and order, and law and order. Now the same article governs Puducherry. Yeah, don't need to put it. Now you can write, apart from this, Jammu and Kashmir, J&K is the UT, having the Council of Ministers, ministers headed by chief ministers, right? Now, like Delhi and Puducherry. Now, if you look at, then you can talk about that certain financial bill, right, need to be need approval of the lieutenant governor. Certain kinds of financial bill needs approval of the lieutenant governor, right? So these are the major changes, right? Apart from it, it can make law, right? Pass budget, and can issue directions and resolution. So these are the basically changes in the nature of J&K Assembly. Now, if you look at the second part of this question, briefly discuss the power and functions of the Assembly of the Union of the UT of Jammu and Kashmir. So very simple. Now, power and functions of the power and functions of Assembly of J&K. Now, if you look at, every assembly has the same functions, right? But if you look at UT, has limited. As I told you that UT like Delhi or Puducherry or Jammu and Kashmir has some limitations. But if you look at power and functions, lawmaking power, right? So it can make law. Second, financial power, it can pass budget, right? Then third, ensures accountability of the government, right? Then fourth, right, provides representation and gives voice to the J&K, right, as well as different classes, right? So these are the basically work of the power and functions of the assembly. Fifth, it has some certain limitations. It has certain limitations under Article 239A, that it cannot make law, it cannot make law on police and law and order, right? As police and law and order is actually governed by the central government, right? So these are the power and functions of the Jammu and Kashmir Assembly, and then you write, the conclusion, basically. Conclusion, right? For 2 or 3 lines about Jammu and Kashmir Assembly. Now, next question, if you look at here, we have the Attorney General of India plays a crucial role in guiding the legal framework of the Union government and ensuring sound governance through the legal council, right? Discuss this responsibility, his responsibility, rights, limitations in this regard. So there is no two question, it is only simple one question, and you need to write in 150 words. So first, if you write introduction, intro about Attorney General, right? So you can write Attorney General is a legal counsel to the Government of India under Article 76, right? And it provides all legal advices to the Government of India and represent Government of India in any court of India, right? Including Supreme Court. So introduction, now come to the discuss responsibility, rights and limitation. So write responsibility, responsibilities. What is the responsibility of AG, that's called Attorney General? The first responsibility is to represent the Government of India in any court, whether High Court, Supreme Court or the local court, right? To represent the Government of India in high in any court of any court in the territory of India, right? Second, it fight the government case on the behalf of government, it fight the case of government, right? Third, it gives legal advices to the government if necessary. If necessary, right? So these are the basically, right, responsibility. Now look at the rights of the AG. Now if you look at the rights of AG, now AG can go to the any court of India, whether High Court, Supreme Court or lower court, in order to represent the Indian government. It can represent or Government of India in any court, Second, AG can sit in the Parliament in the either house of the Parliament, she can speak, right, and discuss matters, right? Third, AG has not right to vote in the parliament. AG has no right to vote in either of the house of the parliament. House of the parliament, right? These are the rights. Now, what is the next point? Next point is limitations, right? What are the limitations of the AG? AG. First, he can speak but cannot vote in the parliament. The parliament, right? Second, he cannot counsel to the any criminal cases while he is in service. Cannot counsel any criminal cases while in office, right? Third, his tenure depends on the duration of the government. His tenure depends on the tenure of the government So these are the limitations, and now you can write conclusion. So look at, there are 3 points that we had made, right? Rights, responsibility, rights, and limitations. So you have to focus equally on responsibility, rights, and limitation after the introduction, and then you have to, write conclusion. You know that we have 150 words to write. So major point you should write. That's all. Now let me move to the next question. Now this is a big question and several times, I think one times already asked in a very recent year, not more than it is I think perhaps in 2021 there was a question on constitutional morality, and in PSIS subject, the last year there was a question on constitutional morality. So see the question and then let's discuss. Constitutional morality is the fulcrum which acts as an essential checks upon the high functionaries and citizens alike. Now look at, you just try to understand the intention of the question. So basically it talks about constitutional morality, right? And basically it checks on the high functionaries, it means the government, right? And also on citizens. Now it puts checks on government, it puts checks on citizens. That is right. Now see the question. In view of the above observation of the Supreme Court, explain the concept of constitutional morality. Simply it is asking, explain the constitutional morality and its application to ensure balance between judicial independence and judicial accountability in India. Very specific we have to be, right? We have to, talk about the application of constitutional morality, right? To balance judicial independence, and second is judicial accountability. Now, first introduction in introduction, one should write what is constitutional morality and also talk about, the constitutional assembly debate, especially Dr. B.R. Ambedkar's statement, what he talked about constitutional morality. So you can write with the constitutional morality, right? Constitutional morality morality, right, is a set of rules, framework, obligations, right, and direction given by the constitution, given by the constitution, right? So you have 250 words, you have some scope to extend it. So this, just after definition, you just go to the Constituent Assembly debate. Constituent Assembly debate. I need to write about, Ambedkar's idea that Constituent Assembly, the constitutional morality should govern the, public spaces, right? Public sphere, and it should be the, a value that guide not only the government but also the citizens. As you know that Indian society is actually based on hierarchy, that is a caste, right? So Ambedkar's idea, and then you come to the, applications. Now you can write about the some of the values of constitutional morality, right, or rules of constitutional morality. Right? What are the rules of the constitutional morality? Now, first you write that, the some of the important points reflects in the preamble. Themes reflects in preamble, like secularism, right, democracy, and republic. Republic. Further, values like justice, liberty, equality, and fraternity, right? Then rule of law, then separation of power, separation of power, then DPSP and fundamental rights, mental rights. So these are the basic norms of the constitutional morality, what we call constitutional morality. Now give the several judgments, judgments regarding constitutional morality. There are, a plethora of judgment. First, you can write case one in Bharti case. Bharti case. That propounded basic structure doctrine. Then you can talk about Navtej Singh Johar case. That argues for priority of constitutional morality constitutional morality over public morality. Public morality. Then one can go for the Sabrimala judgment. Judgment, right? In which Supreme Court held that right, that constitutional morality should prevail over the public morality or majoritarian morality. Constitutional morality should prevail over majoritarian morality. Majoritarian morality. Now, question is here. Now we have talked about the several judgment. Now I'll talk about now how this constitutional morality ensures judicial independence and judicial accountability. Oh, right. Now, if you look at the constitutional morality, I'm just erasing this because of the lack of space. Do you have space? No. Right. Now look at how constitutional morality ensures constitutional judicial independence. Constitutional morality for shaping judicial, right, for ensuring judicial independence. Judicial independence. Now, if you look at, here you can go for the Keshava Bharati case. Keshava Nand Bharati case, where the Supreme Court held that the basic structure cannot be damaged by the Parliament under Article 368. Right? So, Supreme Court in Keshava Nand Bharati case, Supreme Court held that the Parliament cannot damage basic structure of the Constitution. Right? Now, if you look at one of the basic structure of the Constitution is independence of judiciary. Right? Second point, next point. One of the basic structure is independence of judiciary. Right? Now, judiciary has protected its independence by several measures. For example, the fourth judge's case. Right? In fourth judge's case, Supreme Court validated the 99th Constitutional Amendment Act, and it also invalidated what that is called National Judicial Appointment Commission Act. National Judicial Appointment Commission Act 2015. Now, if you look at this, constitutional morality. What is constitutional morality? Constitutional talks about independent judiciary. So, right, constitutional morality talks about independent judiciary, right? Fifth, independent judiciary. Right. Because if you look at the making of the Indian Constitution, it talked about the judiciary must be independent in India, and that's why judiciary is free from several constraints. For example, look at the for salary and maintenance of offices. The judges are not, a judiciary is not dependent on the parliamentary approvals of the budget, because they are charged on the expenditure, done from the consolidated fund of India. So their salaries actually expended by the charge upon, right, consolidated fund of India. Right. Now look at judicial accountability. Look at judicial accountability. How judicial accountability is ensured by the constitutional morality. Accountability. Right. Consider, right, making rights of the people. For example, Supreme Court has declared several rights as a part of fundamental right. Several rights as part of fundamental right. For example, right to education. You can write JP, right to education. Education. In JP Krishnan versus State of AP, State of Andhra Pradesh. Right. Now, for example, uh, uh, declaring IPC 377 and allowing homosexuality. So, as he declared IPC 377, right, unconstitutional, right, and allow adults to choose their sexual partner. Now look at judicial accountability. Judicial accountability means judiciary should work for which it actually stands, right? So it allowed, it decriminalized the homosexuality. Then if you look at, it extended again several other rights, right? Look at, through judicial activism, right? Look at the Sabrimala judgment, right? Judiciary spoke for the rights of the woman. For rights of woman, right? Now look at judiciary talks about right to environment. Judiciary, explicitly, mentioned a right to environment as a part of fundamental right. Fundamental rights, right? So there have been several judgment, right, that actually, balanced or that actually delivers the accountability of the judicial system. So you can write conclusion that the constitutional morality, has shaped basically or ensured a balance between judicial independence and judicial accountability in India. Now let me move to the next question. Now this is again 250 words. Indian Constitution has conferred the amending power on the ordinary legislative institutions with few procedural hurdles. Right? In view of this statement, examine the procedural and substantive limitations on the amending power of the Parliament to change the Constitution. So basically, you have to write about amendment of the Indian Constitution. So introduction mein you can write, in intro you can write Indian Constitution is a dynamic one, right? And it can be changed according to time and circumstances. The Constitution provided Article 368, 368 to the Parliament to amend any part of the Indian Constitution, right? So that is, you have to write about introduction and then talk about, what is the power of the article, power of the Parliament under Article 368. So power of the Parliament under Article 368. Right. Now, what is the power of the Parliament under Article 368? The Parliament, right, by either simple majority or the special majority can amend the Indian Constitution. Right. Now, through simple majority, it can amend several parts of the Indian Constitution. For example, it can, amend the idea or any provisions related to citizenship, right? Then also about election, right? Then about second schedule, right? So these are the simple majority. Look at the by special majority. A special majority. Now, if you look at the special majority, it needs, the support of the total. It needs support of the majority of the total, right? So for a special majority, right, for a special majority, Parliament requires majority of the total and that should not be less than, and that should be not less than 2/3 present and voting. Right? So this is constitutional provision. Now look at the procedure for amendment. Procedure for amendment. Right? Now it can be presented to the any house. So it can be presented to the any house, either Rajya Sabha or the Lok Sabha. When one house passes it, is sent to the second house, right? Then when the both houses passes it, then it goes to the president, and president has to sign the constitutional amendment bill according to 24th CAA, right? The president is basically compelled to sign it, right? And he cannot use veto. Right? Now look at the limitations on the amending power of the Parliament. Now come to the limitations. On amendment. Now first limitations, if you see that, the first is a special majority. special majority? It means any amendment, or any amendment bill needs to pass by the special majority. What is a special majority? A special majority means, the majority of the total house, majority of the total, and 2/3 of present and and voting. So this is very difficult. It's not so simple. Now, second, if you look at federal matter, right? Federal matters needs consent of the more than half of the state, need consent of more than half of the state, right? Third, if you look at basic structure doctrine, basic structure doctrine. As you know that, Keswan Bharti case, the Supreme Court held that the Parliament under Article 368 cannot amend the basic structure of the Indian Constitution. So, the Parliament cannot do it, right? So, Parliament cannot amend basic structure. Parliament cannot amend basic structure of the Constitution according to the Keswan Bharti case. Keswan Bharti case. So these are the limitations on the on Parliament for amendment, right? And then you write conclusion. Okay. So this way you should write answer. Now let me talk about the next question, right? Our next question is about collegium system. Everyone knows, right? Last time in BPSC this question was asked, right? So evolution of collegium system in India, critically examine the advantages and disadvantages of the system of the appointment of judges of the Supreme Court and that of USA. So both you have to talk about US and India. So this question has two parts. First is you have to explain what is evolution, what is about evolution of collegium system. So first you can write about the collegium system, right, in introduction. Right, introduction, right, that 2-3 line you can write about collegium system. That collegium system is a recent innovation in Indian polity that appoints judiciary in India. However, in US, it is executive that appoints judges in the Supreme Court. So you have to mention both India and US, and then you talk about the collegium system, right? So you have to talk about first judge's case, that is called SP Gupta case, right? 1980, and you have to write what was the Supreme Court argument, right? Supreme Court argued that the word consultation does not mean the concurrence. So before you write first judgment, right, you should also write Article 124 clause 1, which talks about the appointment of judges. So in first judge's case, so who appoints the judges? The president appoints the judges, after consultation with the CGI. Now in SP Gupta case, the word consultation with CGI does not mean concurrence, right? Now you have to write second judge's case. Second judge's case, that is 1993. Now Supreme Court held that the word consultation with CGI means concurrence, right? So here he said, the Supreme Court said something different. Concurrence, not concurrence. Now it was because time was different, right? It was a Indira Gandhi time, which was a majority government in 1993. Now it was actually minority government in 1993. In 1980, it was a majority government by the Indira. In 1993, it was actually, the weak coalition government, right, or minority government. Then you have to talk about third judgment, third judge's case 1998, where the Supreme Court held that the word consultation means concurrence, and the president will not consult only the CGI, but the CGI plus 4 senior most judges, and Collegium system has come. So Collegium system, which is established by the second judge's case, was strengthened by the third judge's case. Then you have to write fourth judge's case. (2015). Now in this judge's case, Supreme Court invalidated. The Supreme Court invalidated 99th Constitutional Amendment Act. The 99th Constitutional Amendment Act, right? It also invalidated National Judicial Appointment Commission Act 2015, right? And it focused on independence of judiciary, on independence of judiciary, right? So the judges of the Supreme Court, SC and SC, are appointed by the president after consultation with Countess's Collegium. Now this has been criticized in India, right? That judges are judging themselves. The Supreme Court has created an umpire within an umpire. So entire judiciary is an umpire, right? And within entire judiciary, Collegium system is very short, very much power holder, and it is led by the only few judges, right? So basically, elite circle captured the appointment of the judges, right? So you have to talk about the Collegium system. Now, however, you have to also mention about the Venkat committee, right? Venkat committee, which actually advised for the for creation of National Judicial Appointment Commission in 2002, right? And if you look at National Judicial Appointment Commission, right, that has been not realized and in India, right? Now we have to talk about the appointment system in US. Appointment of judges in the US, right? Now the president appoints judges in the US, right? And it is subject to Senate approval, right? So legislature has command over the a bit command over the appointment of judges in the US. But now let me talk about the advantages of India and US. So Collegium system, right? You have to talk about advantages. right? So 1, 2, 3, right? Then you have to talk about disadvantages, right? Again, 1, 2, 3. Then, appointment of judges in US, right? Then again, you have to talk about advantages, right? 1, 2, 3. Then again, disadvantages, 1, 2, 3. Now look at the advantages of collegium system. That actually, independent judiciary, independent judiciary. Second is no intervention of the executive, right? Impartial, right? What is the disadvantages of this system, right? Nepotism, right? Judges are judging themselves. Judges are judging themselves, right? Judges are judging themselves. Then controls of a minority, right? Controlled by minority. Minority. You can give, report, for example, as per newspaper report, as per newspaper report, 300 families controls Indian judiciary. Controls Indian judiciary. Right. Now you have to talk about appointment of the judges and then advantages and disadvantages. Advantages, it is appointed by the executive, appointed by executive, right? Legislature intervention, legislature intervention, then discussion and debate, discussion on appointment results in consensus. Consensus. Now these are the basically advantages. Now look at disadvantages. Highly politicized, highly politicized, right? Politically influenced, politically influenced, right? Then biased appointment, right? Because political party which controls US polity appoints judges in US. And now it was a big question, right? Now you have to write the conclusion, because it was 250 words, so lots of things you have to write. Then you need to write conclusion about the judiciary system, whether in India or US. Now look at the next question. Examine the evolving pattern of center-state financial relations in the context of planned development in India. How far have the recent reforms impacted the fiscal federalism in India? Now you have to write about the center-state financial relations, right? So introduction, I'll write very briefly introduction. You have to write the anything that you thinks fit. For example, any central any healthy federalism can sustain with healthy financial relations between center and states, right? And the revenue should be distributed between the center and the states, all right, for more healthy relations and democracy, more deepening democracy. So after introduction, you can give the centrist, evolving pattern of centrist financial relations. So if you look at, the you can divide into two phases. Center state financial relations. Before two phases, you just give a constitutional provisions like centralist. The center has right to levy taxes, state list, right? The state has a right to levy taxes, right? For example, liquor, right? Liquor. Then you have to talk about Article 275, that is grants in aid. Then you can bifurcate it, grants in aid, that is constitutional aid or legal aid, and that is legal aid and discretionary aid. Discretionary aid. Now come to explain, the evolution, right? You can write about one more article, 279, 279A, that is GST Council. GST Council, right? And then you can divide this financial relation between center state into two parts. One is center state financial relations between 1951 to 2014. Now here you have to write about, look, there are two pillars of financial relation. Two pillars of financial relation. How? That is, one is finance commission and second is planning commission. Planning commission. Now if you look at planning commission, was an important institutions in order to design the plan and also give aid, right? Also investment aid to the different states. For example, till from since 1991, Tamil Nadu is a state which received most of the developmental aid from planning commission, right? Because one party, either DMK or AIDMK, was the part of the coalition government at the center. So planning commission was an important pillar of development, development for states, and also fiscal relations. And finance commission recommendation, if you look at, aid is given on the basis of finance recommendation by the finance commission under article 280, right? Now planning commission is actually dissolved. There is no planning commission. Now you have new only finance commission, right? So look at the new mechanisms. Right? So look at the 14th Finance Commission recommendation that has given that 42% revenue should be given to the states. To states. Now 15th Finance Commission said that 41% revenue should given to the state and 1% go to the JNK. Right? that is J&K. Then if you look at GST Council, right? Now GST Council under Article 279A, right? They can collect revenue and it can be shared by the state, shared with the states, right? So GST Council is there. Now you can talk about, that government schemes, centrally sponsored schemes, centrally sponsored schemes. Now what happens in centrally sponsored schemes? 60% is given by the union government and 40% share is given by the states. And if you look at centrally sponsored schemes, there are several centrally sponsored schemes, right, which is center declares without taking the consent of the government, state government, and that actually putting the financial burden on the state government, right? So that is basically one, right, one dimension. Second is we look at cess and surcharge. Cess and surcharge. Now, cess and surcharge is exclusively belongs to the central government, right? Basically, belongs to the central government, right? Now, if you look at, the as per the Tamil Nadu government white paper, right? TN white paper report. Now, if you look at the cess and surcharge share used to be now 90 is to 10. 90% is to 10%. So 10% surcharge and cess, right, and 90% from tax revenue. This is in 2010. In 2010, out of 100, 10% used to be cess and surcharge, and 90% used to be the collected tax. Now, what happened in 2021? There is a 80% collected revenue and the share of surcharge increased to 20%. Now, if you all know that cess and surcharge is not shareable with the states. So what happened? It gives the extra burden, right? So state government can share only with the 80% collected revenue, and rest 20% is kept by the union government, right? So this is something, the new framework that we have talked about, right? Reform, and it basically the new reform, right, about cess and surcharge, about the GST Council, about the centrally sponsored schemes, right, that has made an impact on the development of states, right, and southern states has actually talked about. Now one more thing, we have not focus, that is finance commission, right? So look at the finance commission, right? Finance commission. Now, Finance Commission has changed the framework of tax distribution. Earlier, if you look at the Finance Commission recommendation was that tax should be distributed on several component, and one of the component is population. So earlier, Finance Commission has recommended, 1971 population, right? 1971 population. But if you look at in the 15th Finance Commission argued that 2011 census should be taken as a but for the basis of the tax distribution. Now what happens when you jump from 1971 to the 2011 census? Then if you see that northern states of India has witnessed in more demographic growth than the southern states of India. And then if you look at the southern states have less demographic growth, right, not fertility growth, and therefore they are actually getting less share in the tax given by the center. So basically the southern states are accusing the center that we are actually being penalized for doing good planning, family planning in the southern states, and the northern states which actually failed to implement the family planning, right, they are getting extra amount because they have more population. So if you look at southern states like Tamil Nadu or Kerala or Karnataka, they are assisting the new framework of the tax distributions and fiscal federalism, right, in India. So that is basically idea about the fiscal relations. Now let me move to the next question, that is coming from international relation, right? And now I'll talk about, yeah, India Africa Digital Partnership is achieving mutual respect, co-development, and long-term institutional partnership. Elaborate. Now, this is a simple question on India Africa relationship. So, one can go for introduction, right? And one can write introduction of their own kind. There is no necessary, there is no uniform introduction, right? So, for example, India Africa shared colonial past and they are part of the global south, right? And they share multiple values, right? Multiple values, like for example, the mutual respect, shared development, and the institutional partnership in the 21st century. So one can go for introduction, and then you have to write India Digital Africa Digital Partnership. Now if you look at India Africa Digital Partnership, Africa Digital Partnership, right? There have been several partnership for digital cooperation and coordination to curb the cyber security, cyber security, for the arrangement of cyber security, and so on and so forth, right? For example, the e-Bharti and e-Arogya scheme, right, for Africa. Then if you look at capacity building initiative, capacity building initiative in Africa, right? Then also, if you look at India's assistance, India's assistance to Africa, right? Like setting of you know um, IITs assisted IITs assisted educational institution, right? Then for the fourth, right, training and and development under ICET, right? International Comprehensive Economic Training. Now, if you look at their training, India is training to the youths of South Africa, right? For example, Lesotho, then other countries, right? Then, if you look at other mutual cooperation, right? Under social dialogue, right? G20 and other platform, right? So this way you can write and then conclude it, right? So this is something that we need to talk about. Now let me talk about, with waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. So first you introduce what is globalization. Globalization, right, it is a interconnected, right, and interdependent, right, among the world for due to the free flow of trade, information, labor, capital, and so on. Now, after the World War II, globalization has taken initiative, and if you look at after the end of the Cold War, globalization has taken pace in the world, right? But then you have to talk about the deglobalization, right? Due to the nationalism or competitive nationalism like MAGA, like Make America Great Again. America Great Again, or uh, finding the glory of China, finding of glory of China, right, right, and you know taking under the influence under the influence by Russia, right? Actually, damaging the globalization, you know, are damaging the objective of globalization, right? So, and now you have to talk about what happened in the the factors of deglobalization or banning of globalization, right? First, the Cold War 2.0, then second, right, not respecting international institution, not respect for UN, WHO, and WTO, right? Third, competitive nationalism like MAGA factors, then right, then economic decoupling, then taking on a new imperialism, right? Then sixth, Russia Ukraine war. These are the basically factors for deglobalization or running of globalization, right? And it has become now due to this, if you look at the nation state actually competing among themselves for for making the nation great again. So there's a new age of competitive nationalism between the US and China and their allies, right? So with this you can and answer. Let me talk about the next question, right? Energy security constitute the dominant kingpins of in India's foreign policy, and it is linked with India's overarching influence in Middle East countries. This is a one statement. Now, how do you integrate energy security with India's foreign policy trajectory in the coming year? Right. So this is actually questions which asking you that tell or suggest also the way that how India can look for the energy security, right? So if you look at, in introduction, you can define India's foreign policy in context of energy security. Define India's foreign policy in context of energy security, right? And then go for, India's cooperation with the different part of the world. India's cooperation with different part of, cooperation for energy, for energy. So first you talk about India and Middle East. Middle East. And if you look at Middle East, has been the major source of, you know, fulfilling India's needs regarding energy, right? India needs 80% of its crude oil and approximately, 75% of its gas. So if you look at in Middle East, you have Iran, you have Iraq, you have UAE, you have Saudi Arabia, right? And India is dependent on these countries, right, for the energy need. Then you go for India and Europe. India and Europe. Here, India is actually dependent on the new green energy and hydrogen-led energy, green technology, right? So India has cooperation with Nordic countries. India and Nordic countries for green technology, right? Now, next you can go for India-US nuclear deal. How India-US nuclear deal can provide energy to India. Thus, you can talk about the Nuclear Liability Act 2010 and what are the problem in India's US nuclear deal, right? Then you can talk about India-Russia cooperations related to India's energy need, cooperation to fulfill India's energy need. Then you have to talk about, right, that India's cooperation with African countries, India's cooperation with African countries, giving you the summary countries for energy, for fulfilling energy requirement. Then you talk about India and Latin American cooperation for energy need. Then self-reliant, the idea of self-reliant that you can talk about fulfilling India's security need. So these are, and then you come to the Middle East due to the Iran. If you look at sanctions from Iran, sanctions for Iran that that US has posed. And if you look at India's dependence on Iran is decreasing. Now, if you look at, on the other hand, India's dependence is increasing on UAE. So India has done a free trade agreement with UAE, right? The relations with Saudi Arabia is good, right? Oman is good, Iraq is good, right? So that you can, write, and then, you can write conclusion. Right. Now let me move to the next one. The reform process in the United Nations remain unresolved because of the delicate imbalance of East and West and entanglement of US, Russian, China alliance. Examine and critically evaluate the East-West policy confrontation in this regard. So you need to talk about, the UN reform. In introduction, you need to talk about United Nations, right? And then you come to talk about UN reform. UN reform. Here there are two types of UN reform we need, UNSC, and one is peacekeeping force. Right, peacekeeping mission, not force, peacekeeping force. Here UNSC reform you need to talk about, right? UNSC reform, right? Right. With veto reform, without veto reform. With veto reform, right? Without veto reform. Veto reform. Now, if you look at countries like China wants without veto reform, right? China wants reform in the United Nations Security Council, but without veto power. Now, if you look at the Western country, including India and including Africa, wants veto reform, right? For example, if you look at L69 group, then if you look at, African Union, G4 countries, Western countries, they all want UN reform with veto power. Now, if you look at China, right, and also China wants reform without veto. Then you have coffee club that actually makes a rival demand. If you look at Pakistan wants veto because it claimed that because India wants veto, we also want veto. If you look at Argentina, right? So also Argentina also wants veto power because Argentina is basically rival power of the Brazil. Now here, if you look at Italy also wants veto power because Germany has already claimed for veto. So multiple claims, right, for veto you can see here. Now, if you look at the why veto reform is not succeeded, right? The issues with veto reform. With veto reform, right? Now, what is issues with veto reform? The first issues that there is no consensus or lack of consensus, right, among superpower. So look at P5. Among P5, all wants, but China does not want. China does not want veto, reform. But apart from China, all wants reform with veto, and all countries supports it, right? But then since China has veto power, so until China supports it, it is not possible. Second is, if you look at uh, the confrontation between US and Russia, China, right? You can see that it is a Cold War 2.0. Cold War 2.0. That actually, undermined institutions or international organizations like United Nations, right? Then if you look at Russia-Ukraine war, right? What happened in Iran-Israel war, right? Now this war, if you look at in these wars, UN Charter has been clearly violated and not respected by the country, right? So, and then if you look at, the issues with East and West, right? Lots of problem is going on. Then if you look at then uh, the US withdrawal from WHO and Paris Climate from multilateral organization. So these are basically the issues with veto reform. Now you can write answer. Now there are two questions on governance, and I have to finish. I have very limited time, right? Now look at the e-governance project. It has, focused on technology and backend integration than user-centric. Of course, if you look at, the e-governance means, in intro you can write what is the meaning of e-governance. E-governance is basically ICT-led, right, governance, right, the technology-based governance. And if you look at e-governance, we have focused on basically the approaches, top-down approach. And what happens, we had focused on technology, right? We have not focused on, the user-centric, right, user issues, right? Now, for example, what are the user issues we have? Now we have, digitally divided society, digital divided society, right? Poor awareness about digital literacy, poor awareness, digital illiteracy, right? Now we focused on technology. For example, we talk about fintech, right? We talked about, industrial revolution 4.0, revolution 4.0. If you look at NEP, has talked about technology, right? Technology. If you look at, there are more than 800, right? More than 800 web portals of the government, right? And that is basically technology and backend integration, rather than say user centric, right? So you have to critically examine this question, and let me move to the next question, right? Right. Now, in contemporary development models, decision making and problem solving responsibility are not relocated close to the source of information and execution, defeating the objective of development. Question is coming, radically, basically. So basically, it is intention of this question is basically look at the top down model, right? Top down model of development, right? So if you look at the model of development, it is basically top down model, right? And we are actually focusing on what? Decision making. We are focusing on decision making and problem solving, right? Basically from the top. And what is happening that basically we are not involving people. People are not involved, right? And that is making the entire purpose of the development, fruitless, right? It is purely fruitless. However, if you look at, the purely decentralization is not good. Purely decentralization is not good, right? Is not good. I'm giving you summary, right? Now, purely centralization is also not good. Is not good. And what is good? What is good? Basically, the combination of the two, right? Some centralization, some decentralization. So you talk about the advantage of centralization, centralized policy, advantages of advantages of centralized development, right? And then also talk about disadvantages of centralized development, right? And then you talk about again, the advantages of decentralized model of development, decentralization or decentralized model of development, right? For example, you can give, the Kerala model of development, right? You can give Narega, MG, and REG. But there are some disadvantages, right? And then you offer new model of development that is called subsidiary model of development. Model of development. What is this? Basically, subsidiary model of development, basically the combination of the centralization and decentralization. Combine the both, right? Combine the both, and then you talk, right? Conclusion, right? So with this I will end here, right? This very short, very precisely I talked about the last few questions, right? Because of the time limitations. See you sometime. Thank you.